Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. This is the Rogers Brief for February 16th, 2023. I'm releasing this on a Thursday evening. Usually I release these episodes either Friday or Saturday, but tomorrow I'm going to be conducting a trial in provincial court, and then after that going off to coach basketball up in Spring Hill High School basketball. So had to get this out before that, or else it wouldn't be until Sunday probably before I could record this. So wanted to get this out in particular because there's been some breaking news just yesterday. The head of the RCMP, the Commissioner of the RCMP, Brenda Lucki, announced her resignation slightly early. The normal term is a 5-year term, which was coming up in a few months' time, but she's stepping down early. So I want to talk about that a little bit. I'm going to talk about some Nova Scotia cases as well. One I mentioned a few episodes ago, this Tweedie appeal, which the Court of Appeal granted the appeal, the Crown appeal at the time. This is a tragic car accident collision out of Cape Breton near Sydney, where a young girl was killed. And so that appeal from the Crown was successful. I'm going to talk about that a little bit. Another case out of Kentville, involving 2 town councillors, allegations of conflict of interest. So that's been ongoing for a couple of years now, and it's finally got a decision from the Supreme Court of Nova Scotia. And I'm going to talk about the William Sandeson case as well. That's with the murder trial of the was soon to be medical student William Sandeson in Halifax. It's a jury trial. It's been covered by the media quite a bit in Nova Scotia, and so had closing arguments over the last couple of days, and instructions from the judge are taking place today, Thursday, and the jury's going to go off to deliberate. So I'll talk about that a little bit. A few other Nova Scotia situations, and then some news stories from across the country, and one that's sort of international. I'll get to those as well. Just touch on some of them briefly, but get to all your legal news that is relevant for Nova Scotians, some across the country and occasionally internationally. That's what I cover here in these videos. So the first thing I'll talk about is the Brenda Lucki resignation. And by the way, I'm sure we'll be talking about this Sunday night with Jordan Bonaparte and Paul Palanga on the Nighttime podcast. And if you're interested, I was talking last week in the Rogers Brief about Lisa Banfield, the spouse of Gabriel Wortman, the gunman in the April 18th, 19th, 2020 mass shooting in Nova Scotia. Miss Banfield's civil case against the RCMP, the federal government filed a defense last week. We talked about that, Jordan Bonaparte, Paul Palanga, and I, on Sunday night, and that episode is now available both on YouTube and as a podcast. So if you look up the Nighttime podcast, click on the links that I've posted on my Facebook and Twitter accounts as well, the Rogers Brief or Adam Rogers NS on Twitter. Okay, so I'm sure we'll be talking about Brenda Lucki. So some thoughts I had on this, and I was talking to Chelsea Bird on 630 CHED in Edmonton this morning as well. So Brenda Lucki was on the job for just under 5 years. Prior to that, she had been the head of the RCMP depot, the training center in Regina. So this resignation wasn't planned. It was unexpected, not terribly unusual for commissioners to have their terms renewed after 5 years, and Miss Lucki, Brenda Lucki, was hard to say whether that was going to happen. There was some signs from the government that they may not have had great confidence in her, especially after the Emergencies Act Inquiry evidence from the Prime Minister. But I think this is a case where she jumped before she was pushed, in a sense. In the testimony she gave at the Mass Casualty Commission, she talked about Vision 150, which is a plan that the RCMP had in advance of their 150th anniversary. And she seemed quite dedicated to that and very interested in the progress of that plan, which was addressing all these systemic issues. And so for her to step out before that comes to fruition, I think, is a sign that she really felt she needed to get out before she was pushed. Now, In the Mass Casualty Commission, and people that have been following along with my commentary will know this, I felt that she was really scapegoated on two sides in her, I guess, testimony there, or her how she was perceived. On the one hand, it was the Nova Scotia RCMP command structure that seemed to be really dropping the ball in the Mass Casualty Commission events, and then the aftermath where they weren't able to communicate with the public. But along comes this message, a note from Leah Scanlon, the communications officer, that she felt Commissioner Lucki was really hard on the commanders, and they were just doing their best. And here's mean Brenda Lucki telling them that they weren't doing so good. Well, that turned some of the attention, excuse me, from the Nova Scotia command structure to Ottawa and Brenda Lucki and some of the people around her. But to me, and I think people following the commission closely, it was clearly the Nova Scotia command structure where the problem was lying. And then, they were very happy to have that attention, that negative attention, shifted to the national leadership. And the national leadership, Brenda Lucki and others, in my view, were asking legitimate questions, offering communications help, because communication was clearly a problem in the Nova Scotia command structure. But then, they were happy to have her being scapegoated and blamed for that. On the other hand, I think the politicians, Minister Bill Blair, Prime Minister Trudeau, were both also happy to have the focus on Commissioner Lucki. You recall that the federal government had a plan to introduce, gun control legislation. They brought that announcement forward weeks ahead, in the aftermath of the Nova Scotia mass shooting, to try to generate support for their impending legislation, the pending legislation. And so, when that decision didn't go well, and the attention was, starting to be, negatively framed against the government, I think they were very happy to have the attention focused on Commissioner Lucki as well, and her role in any alleged political interference. So, treated unfairly in a sense, certainly in the Mass Casualty Commission inquiry and the evidence and situations related to that. Now, the Freedom Convoy might be another story. There was, as you recall, people were watching the Emergencies Act Inquiry proceedings. Most, like CSIS, the Ottawa Police, Ontario Police, other people, public safety advisors, were all advising the government, the Prime Minister, to invoke the Emergencies Act. There was one person, and that was Brenda Lucki afterwards, who said that she felt there were policing strategies and things they could have done differently. But the problem was she didn't raise that directly with Cabinet when she had the opportunity to do so. She was in a Cabinet meeting where they were getting all this advice. She didn't raise her hand and say, hey, hang on a second, going against the tide. Certainly it might have been a difficult or courageous thing to do under the circumstances, but she just didn't do it. And so the government didn't get that advice from the RCMP. And so I think that's not going to reflect great on her personally in the RCMP as an organization. And that report, the Emergencies Act Commission report, is going to be coming out in the next few weeks, potentially even sooner. And so, I think she's trying to get out in advance of that report and not be so much in the hot seat when that comes out, and particularly if it's critical of her and the RCMP. So what's going to happen? She was supposed to be an agent of change. It's very difficult. It's a big ship to turn around, the RCMP as an organization, a bureaucracy. So the next RCMP commissioner, I wouldn't be surprised if there were calls to get an outsider, somebody with policing experience certainly, but also management and organizational structure experience that can do some reforming. Be interesting to see if, the initiatives in Alberta, potential initiatives in Nova Scotia to replace the RCMP with provincial police forces means that the next commissioner of the RCMP is going to be managing a reimagining of the RCMP. And so particularly if that's the case, if that's what the public sentiment is, if the government agrees, then to get somebody that's going to manage that, it'd be a decline in numbers perhaps for the RCMP, but just a reimagining of the structure of it. I think that would be better to have somebody coming from outside the organization rather than somebody that's been raised and gone through the ranks and is more ingrained in the RCMP culture trying to do the same thing. All right, so we'll talk about that more Sunday night with Jordan and Paul on the Nighttime podcast. Usually starts at 9:15 Sunday nights, live on YouTube, and then later as a YouTube video and a podcast. So, okay, next story. We'll get into Nova Scotia here. There was an appeal release, a decision released yesterday on the Tweedie appeal. Tweedie is the driver of the vehicle who struck a young girl near Sydney in Cape Breton, killed her. He was acquitted at trial by Justice Mona Lynch, and he was acquitted on the basis that he said he thought he hit a deer, and there was evidence that that she accepted that it was dark. He may not have seen exactly what was happening. There were lots of deer in the area. The road was bad. So some questions about whether he would have understood that he hit somebody and should have stopped. Well, the Court of Appeal, after the appeal, had indicated that they were going to allow the appeal from the Crown. Crown appealed this. So the other circumstance was that he had some alcohol in his system, had been having a few drinks, playing some darts with a buddy of his. Not far from where he lived is where this took place. And so, but he left, he went past the accident, came back, was only tested some 4 hours after the collision took place. And there was an expert called at the trial who extrapolated back to his blood alcohol level, and there was a range, and it depended on when he had his last drink just beforehand. And so all of that evidence, the expert evidence, seemed to suggest that he may have been below the legal limit of 80 over 100, 80 milligrams and 100 milliliters of blood. And so, the judge took that into account when determining whether he was impaired at the time and all that, because he was charged with impaired causing death. Also charged with failure to stop at the scene of an accident. So the Court of Appeal, and this was Chief Justice Wood, Justice Bourgeois, and Justice Derrick as the three-judge panel, talked about one thing was the impaired side, which was instead of using the expert evidence to extrapolate back to the time of the accident, okay, so he was tested at 1:51 a.m., collision took place at 9:42 p.m., so it was about just over 4 hours later. Well, the law is now that you can't be within 2 hours within 2 hours of driving, you can't have over 80. There's a presumption in section 320.31 sub 4. These are all very new laws in the criminal code. People familiar with the old drinking and driving laws, things are much different now. The presumption is if you test after 2 hours, so you're not allowed to have over 80 within 2 hours, and it's designed to prevent all these defenses of people that would go home and drink, or they would drink just before, and there was, all of this expert evidence about what your impairment level was at the time, and it was a complicated calculation. Well, it's much simpler now. If you're within 2 hours of driving over 80, then you're just as guilty as you were if you had been over 80 at the time. And if you're tested hours later, in this case 2 hours past the 2 hour time frame, then there's a presumption that you add 5 milligrams per 100 milliliters for every half hour of time afterwards. So in this case, he was tested at 1:51, blew 60, but you add those 5 times 4 half hours back and you get to 80. So the Court of Appeal found that the presumption in section 320.31 sub 4 means that at the time or within the 2 hours that Tweedie was impaired. Now, the Crown wanted the Court of Appeal to just then enter a conviction. He was impaired causing death. But the Court of Appeal disagreed with that. They're sending it back to the trial judge to determine if he was impaired such that impaired and also caused the death. All right, so there's some causation issues that the next trial judge is still going to have to grapple with. So, second issue on appeal was the failure to stop the accident, and the issue there was whether the trial judge had properly considered the possibility that Tweedie was willfully blind to the fact that he had struck a person and not a deer. And in favor of that was, well, his airbag went off, he was only a short way from home, would have been safe to just pull over and check on things, but he didn't. He kept on driving, even though he had poor visibility, had opportunity to stop, all of those things. Tweedie says he was worried that, if he stopped the vehicle, he might not be able to start it again and these sorts of things, but the judge kind of considered the circumstances around it, but didn't articulate particularly that she considered the issue of willful blindness. So you can know that you've hit a person and then keep going. You can be reckless as to whether you hit the person, and then you can be willfully blind, which is where you basically convince yourself in a sense that you didn't, or you ignore obvious things that you should have clued into that makes you stop. All right, so that'll go back to trial as well. The third issue was just an overall assessment of the evidence, particularly on the lighting conditions. There was evidence from a driver that went by just a minute or two after the collision who said that the lights weren't, lighting wasn't an issue. And of course, the accident happened, the collision happened at a time of the night where it's quickly getting darker. And so the, evidence from a little bit later when people were searching for the little girl with flashlights and such seemed to have led the trial judge to believe that it was darker than it may have been at the time, 9:42, when the collision actually took place. So retrial is going to take place on this, and difficult situation for the family, everybody involved. Hard to say how much different the trial will be on the next go around, but with that presumption, and all of a sudden we now have the presumption in place that he was impaired at the time of the collision, it's going to be more difficult for Mr. Tweedie to defend himself, I think, next time around. So we'll see when that comes along, what takes place. Okay, next situation. This is down in Kentville. This is a municipal government situation, and one that's been, I saw in the magazine formerly known as Frank Magazine, had covered this story a few times. Lots of turmoil in the Kentville Town Council from what I can see on the outside looking in. This was two councillors, Andrew Zebian and Craig Gerard, both town councillors, and the allegation was one of a conflict of interest on the part of Craig Gerard. Okay, judge decision was from Justice Gail Gachalian, and the lawyers for Andrew Zebian was Richard Norman from Cox and Palmer, and for Craig Gerard it was John Shanks from Stewart McKelvey. So two of the big regional law firms involved in this. So that gives you a sense maybe of the resources of the litigants, and I guess their determination to put their best foot forward. So okay. Zebian owns a company called Mike's Clothing Limited, and Mike's Clothing Limited bought a vacant lot on Main Street in Kentville, referred to in the decision as the Robinson property. I assume that's a historical reference. So bought from the town on a conditional sale. The idea was that Mike's Clothing, owned by Zebian, was going to construct apartments there. The conditions were to meet certain deadlines on construction. None of them were met. They were not only not met, but nothing was taking place. So you were supposed to have dug out and put footings in by a certain date, hadn't even dug out the ground yet. Some of this was during the pandemic. So anyway, the town council granted 3 extensions. None of those extensions were met. And on the 4th request for an extension, council rejected it, and then were asked a month later to reconsider their rejection, and then didn't reconsider it. In other words, voted again to confirm that they were rejecting the extension. So then, therefore, the land would go back to the town. Well, Zebian says that Gerard was in a conflict of interest because he and his family own other commercial real estate commercial real estate and apartments in downtown Kentville, so would have been a competitor of this new development and therefore had a pecuniary, a financial interest in seeing the development not take place, and therefore was in a conflict of interest. So that's a big deal because in the Municipal Conflict of Interest Act, which is the only way to get rid of a councillor. All of these, this came up during the Rob Ford thing in Toronto. The only way to get rid of a councillor is for if they've voted or done something that puts them in a conflict of interest. You know, behavior, all of those things, missing, you know, that doesn't work, but conflict does. So Section 6 says if it's of the Conflict of Interest Act, if it's a conflict, the councillor must withdraw and not vote. And if the act is intervened, then a court can declare the councillor's seat to be vacant. So the question was, did Councillor Gerard have a pecuniary interest? The judge says no. The evidence was that Gerard's properties, the family's properties, were completely full. Anytime there was a vacancy in any of the apartments, it was filled immediately. Different price range, more in the $1,000 range rather than $1,500 as the new development was going to be. And so what the judge found was that the mere possibility of competition wasn't enough to establish that there was a pecuniary interest and a conflict. By the way, Gerard not only voted for the purchase and sale agreement, he also voted for the first and second extensions of that. So it wasn't as though he was against it throughout or at every stage. Probably a predictable outcome, but that was the outcome. We'll see what happens next if Councillor Zebian, I mean, they seem very determined on these things, if there's an appeal there. The appeal, I guess, would be, well, is, you know, the mere possibility of competition within the same industry. I mean, even if you're not directly even if things are going very well for one apartment building owner, doesn't mean that might not change in the future, but we'll see. Okay, a few other cases, and then the last one I want to talk about is the William Sandeson, but just a few other things that were catching my attention this week. One, I noticed that the parents of Dylan Ealer, Jason Ealer, I guess in particular, have taken the Truro Police Services to the Nova Scotia Police Review Board. This is an oversight body for municipal police forces, not the RCMP in Nova Scotia. Just alleging that when their son went missing, that the Truro Police Service didn't communicate properly, didn't do their jobs. Can't see that coming. I just following the story a little bit, I don't see the Truro Police being found at fault there. Looked like, you just watch the news reports and the number of people searching and in the water and doing everything they could to try to find that little boy. So, tragic circumstance, and one where probably Jason Ealer should probably, try to get on with his life and not keep bringing these things up. But we'll see what the police board does with that. It's a 3-person panel that is making that decision. Across the country, out in BC, the RCMP is being sued by Narwhal Magazine, which is an online non-profit magazine. There was a journalist covering a protest in the one of the First Nation reserves out there. There's some logging going on, exploration. Anyway, the journalist was covering this and was detained and arrested for 3 days by the RCMP. And so Narwhal is now suing the RCMP for that. Press freedom issue, so we'll be watching that closely. Would suspect the RCMP to be found at fault there. There's a lot of leeway for journalists when they're covering incidents like this, and that wasn't respected. A couple of inquiry-related sort of news. One is the James Smith Cree Nation, the coroner's inquest into the stabbing deaths, multiple deaths out in the James Smith Cree Nation. That is going to start, it's been announced in January of next year, 2024, so that'll be an extensive inquiry, I would think, into the actions. Remember that the Saskatchewan RCMP in that case did use the public alert system to let people know what was taking place or what they knew. So that building off the Nova Scotia RCMP's failure to do so. And the last one is the next one, Emergencies Act, inquiry. That report's going to be coming soon. Who knows exactly? We don't know exactly when, I don't think, but that report is going to be coming down very soon about whether the government was justified in invoking the Emergencies Act in response to the Freedom Convoy, Truckers Convoy, however you want to frame it. Okay, last story I wanted to mention is something, a Canadian connection, and there's been some sort of academic, at least, commentary, judicial commentary in Canada. Canadian retired judges, including retired Chief Justice Beverly McLaughlin, other Supreme Court of Canada retired justices, law professors, lawyers across the country are very upset about changes to the judicial structure in Israel. So Israel has voted in a right-wing government of Benjamin Netanyahu, considered to be a right-wing government, who has brought in limits not only on the Supreme Court's ability to revoke laws that have been passed by Parliament, as happens everywhere else, any other democracy, the UK, Canada, the United States. The Supreme Court has the ability to strike down laws made by the legislature if they're found to be unconstitutional. And not only that, so they're limiting the ability to strike down laws. They would have to have a unanimous decision from the 15 justices of the Israeli Supreme Court to do so. And then more power for the government to then decide who becomes a judge. So you can see that as a real erosion of judicial authority, and then really an erosion of democracy, because democracy is more than just voting. It's institutions like the oversight that a Supreme Court can provide to make sure that an elected parliament doesn't go overboard to pass laws that are unconstitutional. So we'll see where that takes us. Just something to watch internationally there. When things like this come up, it seems like democratic institutions, democracies from around the world react when other democracies seem to be sliding back or sliding into undemocratic territory. All right, last thing I want to talk about is the William Sandeson trial, which wrapped up, is wrapping up today, Thursday, in a sense, with the Justice Chipman giving instructions to the jury. By the way, that process of giving instructions, instructing here's what the law means, here's what you should know, that takes hours in even the simplest cases. So that'll be taking up a good chunk of the day on Thursday. Yesterday there were closing submissions from the defense lawyer Alison Craig and the Crown lawyer Kim McConney. Not the same Crown lawyer who was doing the cross-examination on Sandeson himself. So that was interesting. Okay, so another point, I guess. Usually at closing, you wonder, all right, which order they go in. If the defense doesn't call any evidence, the accused doesn't take the stand, it's just a Crown case, then the Crown goes first and the defense second. If the defendant calls evidence, takes the stand himself, or calls any other evidence, then it's the defense lawyer that goes first in closing arguments. It's kind of nice to go last. You do get a chance to rebut anything that the other side brings up in their argument if you're going first, but it is kind of nice to go second, so you can react more to what the other side is saying in their closing submissions. So the jury will be off deliberating. Hopefully they don't come up with a decision before I post this video. If they do, I'll certainly try to make a note along with it. So the defense submissions has said that this was an unplanned situation. He admits to killing Taylor Sandeson in his apartment, but claims that it was done in self-defense, that they wrestled. Taylor Sandeson was trying to get Sandeson's gun. Sandeson recovered the gun. Then Sandeson went to lunge at him, and Sandeson shot him, killed him with one shot. The Crown suggests that this was a planned and deliberate killing and was motivated by Sandeson wishing to get money from Sandeson. He was supposed to be a $40,000 drug deal. Taylor Sandeson had the drugs, brought the marijuana to Sandeson. Sandeson only had $10,000 on him and was trying to suggest, he claims, at least to Sandeson, that he had got the rest of the money by robbing another drug dealer. Anyway, there was a sort of a cross owing of money that Sandeson seemed to think was justification for him not having the $40,000. But anyway, that was not a separate issue, but not the main issue. To me, there's things about the Crown case that don't add up. Not really much money for Sandeson, who's on his way to med school. You know, he's making $8,000 a month from his work and from dealing as it is. So to make, even $20,000, $30,000, if he was able to get that from the other marijuana that he was going to thus have for free, in a sense, by killing Sandeson, you know, for somebody that's going to be making $500,000 in a few years' time and could get basically unlimited student loans as a medical student, that doesn't particularly add up. And also, it was a very bad plan. You know, there he is, you know, shooting somebody, which is going to be loud, draw attention, could have drawn police, you know, in minutes. And there he is, you know, having to clean up an apartment. The other things that don't add up, he appeared dazed afterwards, Sandeson did. He talked to his neighbors. He said he considered suicide. He was panicked. Not things you would expect if you had planned these things out. Like I say, he had money and really stooped to throw away a career over this, as his lawyer Alison Craig pointed out. He had de-identified his apartment. Okay, so that means he took anything out of the apartment to make it look like he lived there, so that, you know, if he was caught or if, you know, Sandeson saw something there, Sandeson wouldn't know it was his apartment. He would just think it was a safe house that he was using for the purposes of the deal. Well, if you're planning to kill the guy, why do you care about any of that? You wouldn't bother de-identifying the place, taking out anything that has your name on it, if you're just going to kill the guy anyway, because he's not going to have anyone to tell. And the other problem with the Crown's case is that Sandeson didn't turn off the surveillance equipment that he had in his hallway. And, you know, he turned it off at one point later on, but he didn't turn it off early enough to not capture Taylor Sandeson arriving, and we see him with the duffel bag in the hallway outside of his apartment. So all of those things don't seem to add up to a planned and deliberate killing. Now, the question is the jury going to believe, though, the jury may believe that there was nothing planned about anything, and so that would take it away from first-degree murder to potentially second-degree murder or manslaughter. Was there a self-defense, though? That's the question that the jury's going to have. Are they going to believe Sandeson about the self-defense? He didn't tell anybody immediately afterwards anything that would support the self-defense argument. He didn't talk to the neighbors and say, "Oh my God, can't believe what happened. He lunged at me. I had to kill him." He didn't talk. None of those things happened at the moment that would have supported this. It's only him claiming now, after having gone through a first trial, after having, you know, had years to think about this, that he's developed, in a sense, this self-defense argument. So the jury may believe that there was no planning involved, but they may not believe that it was self-defense and come back with an included offense conviction on the, you know, a second-degree murder or manslaughter charge. Wouldn't be shocked at that, but, you know, if Sandeson, if he was compelling on the stand, you know, everything else about his story seems to add up in a self-defense scenario. So the jury may just accept that and acquit him. So it'll be very interesting. Now, if they go for if they come back very quickly, it usually means that they're going to convict him. If it takes them a little while, and if they have any questions for the judge, that's probably leaning towards acquittal. So we'll see how long they're out deliberating. In any event, once that comes back, if you're following along, you know, I'll try to post it somewhere as well, but I'm sure the news will be big once the jury comes back and gives their decision. So we'll talk about that next week as well. Surely they'll be done deliberating by then. I wouldn't expect it to take more than a day or so to sort through some of these things and the evidence, and maybe have a verdict before the weekend. A lot of the juries, they like to get their verdicts before the weekend, or else they're, you know, could be sequestered over the weekend in a hotel away from their family and everything else. So Would be expecting a verdict Friday afternoon. So we'll see about all that. All right, that's it for this week. I hope everybody enjoyed the content. We'll be back next week with some of these updates and others. And then, like I said, you can catch me Sunday night on the Nighttime Podcasts with Jordan Bonaparte at about 9:15 on YouTube, and then afterwards by podcast, Apple, and Spotify. Okay, that's it for now. Thanks everybody for watching. Thanks for listening, and we'll see you next time.